power to distribute is called a power appointment. Nothing to do with an appointor. I'll come next to an appointor. This is a person often named, at least first named in a beneficiary, but can be substituted later. It's probably one of the most misunderstood areas of trusts. An appointor is a person who has power, generally, to sack a trustee and appoint another in his place. Too much is read into that power. We've had cases where the federal court has, and now the Chief Justice of the High Court, has considered that an appointor has far more importance in the trust to that which he has. Yet the appointor is no more than a person who can direct the trustee to retire and give the trust property to another person, still bound by the same trust terms. So often you hear the case that an appointor is one who controls the trust. That's not generally true, because the appointor can simply sack a trustee, but the next trustee is as much bound as his predecessor was to perform the trust obligations, the powers and the trusts and the trust deed. So the appointor is not particularly an important animal that is often perceived, largely by accountants, to be more valuable in the trust mechanism than he is. Many trustees don't have appointors. In the case of class trusts and some unit trusts, the role of the appointor in sacking a trustee and appointing a new one lies in the beneficiaries, where property ought to lie. Their interests are the ones economically at risk. So the trustee is directed by those who have the greatest interest in the trust to retire and be appointed by another, and that generally is something that the appointor, if he's some removed from the beneficiaries, will be ill-suited as a role to fulfil. So appointors are not greatly important. Others disagree, but there are things I might return to later as further reasons why the appointor is a role that should be deprecated these days. So they're the three roles. Now, I've mentioned the trustee. Oftentimes, the trustee, I've mentioned before, is a corporate entity, a company, a private company that is proprietary limited, and often has no other function or duty to perform than to act as trustee and conduct whatever business it conducts in its capacity as trustee if the trust is running a business. It is often controlled by the principal beneficiaries and is one whose shares are held by those same people, often by those same people. I'll return to that a little later when it comes to how you should structure that, but for the moment it's a corporate trustee, and the board of directors of the corporate trustee will comprise, if more than one director, the principal beneficiaries, or often the principal beneficiary of the trust. Now, several reasons for this. One is that if the trust gets into, and I'll use that loosely, trust, if the trust gets into financial difficulty, by which I mean the trustee gets into financial difficulty in his capacity as trustee of the trust, then what is likely to happen is a liquidator will be appointed to the trustee company, and that liquidator is entitled to recoupment from the trust assets those monies necessary to discharge the debts of the company incurred as trustee. Only the trustee can be sued in respect of them. The beneficiaries can't, generally speaking, be sued. Often there are trusts poorly set up that will allow that. But in a case like this, and I'm talking typically of non-fixed trusts, discretionary trusts, the beneficiaries will not have any liability to creditors or to the trustee. The beneficiaries will oftentimes be guarantors to the trustee's banker, and that is, in a most practical term, where their risks will lie. And the bank will go after the beneficiaries and won't often care about the trust unless there's secured property in the trust that is security for the bank debt. So it doesn't help the hapless beneficiary that he's given a guarantee, because he's liable on that. Not because it's a trust, but simply he's a guarantor. Now, the trustee company will be liable, as I say, and the directors may, in some circumstances, be personally liable. For example, if the trustee has been trading insolvently, and that can be because there's not sufficient trust assets for the trustee to recoup itself from those assets and discharge of liabilities it's incurred within power, or that there's some restriction or impediment on the right of recoupment in the trust instrument, rare but it's possible, then in which case the company is trading insolvently without any reasonable expectation of payment of its debts. The directors of the trustee company can be liable in that case, in that circumstance, as any directors of any company can be, not because it's trustee, but simply as trading insolvently. And in cases of that kind, the feckless directors are the ones who will be looking down the barrel at a suit brought against them by a liquidator for trading insolvently, and the liquidator discharging the proceeds of that collection to the creditors. But that's an unusual circumstance, and in practical terms, it's only if there's many hundreds of thousands or millions involved is that likely to sheet home to a liability. So that's the trustee. I haven't said much about the trust itself, and I'm leaving this to last because it is not well understood, even by people who deal with them every day. In a lazy and compendious way, we talk about trusts as if they were things, as if they were people, that is, had a legal persona. They don't. A trust is no more than a simple obligation on a person who's possessed of property impressed with the trust to deal with it in a particular way. It's an obligation. We treat obligations as if they were people, separate and apart from the people on whom that obligation is imposed. They're not. A trust is simply just the obligation, but because of the way the Assessment Act, the policy of taxing trusts, has been formulated over the years, and ever since the first Assessment Act this has been so, they treat the trust, or at least the income of the trust, as if it were the income of a person. That's what the Income Tax Assessment Act says. And in doing so, we loosely fall into the trap of talking about trusts as if they were things. They're not. There's no such thing as a trust in law. The law doesn't recognise trusts. And they're not people. You can't meet and shake hands with a trust, but you can to its trustee. So therefore we loosely, and we get into the habit of making mistakes by treating trusts as if they had a legal persona. We know and well understand companies and individuals. Partnerships don't have a legal persona, and nor do trusts. But trusts are all the more obscure because at least in partnerships there's a partnership between people or things that have a legal persona. Trusts do not. And therefore I stress the point that so much of the confusion that arises in trust, and the confusion as much in tax legislation as in general perception, that a trust is a thing that you can touch, feel and tax. Now, having said that, I might touch now on the logical ownership of the sheep. This is often an area of deferred problems. Deferred because when the wills are drawn of the principal beneficiaries, mum and dad, in a family position, we find that mum and dad, or dad, own shares in the trustee company. And in their wills, they leave those shares to their children. Partly because the shares are inherently valueless, because the company owns nothing in its own right, and often under the mistaken view that it doesn't matter the identity of the person to whom the shares are left. Well, it very much matters. There is little more I can think of that is destined to cause trouble within the next generation than doing just that, leaving the shares in the trustee company to individuals. You are setting them up for a fight between themselves. because him who owns the shares in the trustee company controls the trust assets. And for children, often children or grandchildren, to whom those shares devolve, often have little idea of the work and effort that's gone into creating the wealth of the trust, and see that as a means of control but not ownership, but a means of getting ownership by controlling the trustee. So if young Johnny receives the shares, $1 shares, if that's all they're worth, he may control tens of millions worth of assets with those shares, and his little sister Susie may be at loggerheads with him, or even browbeaten if he receives more shares than she does, into accepting his will in the plundering of the trust. It is almost guaranteed to set up a fight for the next generation to do that way. Now, while I'm on this subject, I'll just mention what is often done to try to ameliorate it. One tactic, a very poor one I might add, is to leave letters of wishes around the place, and where the executors of the estate wish for the children to behave in the disposition of the trust subject matter when they're controlling the trustee. And that is wholly unenforceable. And in fact, in many cases, the trustee is bound to disregard it, because the trustee cannot fetter the exercise of his own discretion. The trustee says that the trustee company must survey the field of beneficiaries and make his own mind up who is worthy and who is not for benefaction. He cannot be told, and indeed he must ignore, directions coming from outside the trust instrument, that is counter to the trust instrument, as this will generally be. In fact, it would be a breach of trust to follow them in many cases, because whilst the late mum and dad knew what they were doing, they can't impose their will on a trustee who has a duty independently of their thoughts to maintain the trust assets and deal with as the trustee directs. So often one sees this, and it's just destined for trouble. I'll mention now, before going through while we're on general trust principles, one quite good way to deal with that problem, and that is to amend the trust deeds so that when, on the death of mum or dad, or the survivor of them, as it often is, the will of that deceased directs the trustee company to deal with the trust assets for particular individuals, that is, beneficiaries of the trust, in particular proportions or ways, and in particular assets, often the case, then the variation of the trust will insist that the trustee perform it. Now there's no conflict of interest and duty on the trustee. In other words, there's no screen between his duties and the intentions of the testator. They are one and the same.
Who is the testator?
The testator is the deceased mum or dad. And that, the will of that testator, testatrix, is what he or she wants the trust distribution to comprise and the composition of it to the beneficiaries. And the change to the trust instrument will mandate that that is what the trustee does. So even if there's an appointor and the appointor doesn't like what's going on, then the next succeeding trustee is as much bound as the previous one was to perform the testator's directions. Those directions in the will can't deal with property of the trust because it's not the testator's property. It never forms part of the estate of the deceased. But it can direct as a component of the trust obligations the disposition of that property to the next generation. So it's almost speaking from the grave, as it were. But it's binding on the trustee. And it's a much better way of avoiding family conflict that would otherwise be set up by letters of wishes and just do nothing, in that it ensures that a problem is avoided before it arises.